Hello, everyone. Welcome to the Canada Truth Channel, where Canada, the illusion of freedom and system of control is exposed. Today's video, we have more on the Statute of Westminster. Um, it's been 94 years since the most important day in the history of Canada for the people of Canada. Most people are um, either completely unaware that it even exists or are unaware what it actually did for the people of Canada and the provinces of Canada. The government for the last 94 years has been completely ignoring it because it nullifies all of their positions and all of their appointees' positions and their ability to rape the resources from the people and land of Canada. So it's very important that we share this information um, along with all of the other information that I'm showing you because no one's coming to save us. To expect a government that's based on deliberate deception and fraud to act honorably on behalf of the constituents, the people that elected them, is naive. So, anyway, this video is from Canada, a country without a constitution, as you can see. It is a factual examination of the constitutional problem by Walter F. Kuhl, Member of Parliament from Jasper Edson from 1935 to 1949. Walter Kuhl was a student, constitutional student of Russell Roger Smith, and brought these issues to Parliament and was mocked. Because, once again, the people in power did not want to lose their power, paychecks, and pensions. So here we go. This was written in January, well, it was published January 1977. So keep in mind, ladies and gentlemen, that it is 48 years later. And we'll look at the foreword and see what Walter Kuhl had to say 48 years ago about the Statute of Westminster that was passed 94 years ago and still ignored. So here we go. Forward. There is probably no political issue in Canada on which there is more lack of information and more misinformation than on the constitutional question. The stalemate and impasse which the governing authorities in Canada have reached on this question seem to indicate that there is and has been something very fundamentally awry in Canada's constitutional history. For almost half a century, this controversy has been raging without a satisfactory solution having been arrived at. Many Canadians, myself included, have had enough of this bickering between politicians and are determined to do something to bring this internecine strife to an end. Does that sound familiar, ladies and gentlemen? The purpose of this booklet is to indicate in some measure what I, as a member of the House of Commons and as a private citizen, have attempted to do to bring order out of this constitutional chaos in which Canada finds herself. Democracy is successful only in proportion to the knowledge which people have with respect to their rights and privileges. It is my hope that the information contained in this brochure will assist Canadians to that end. Immediately following the recent Quebec election, I sent to Mr. René Lévesque a personal letter in which I indicated my conception of the constitutional rights which the provinces of Canada enjoy at the moment. At the conclusion of this booklet will be found a reproduction of this letter. Included with this letter was the additional material found in this booklet. A copy of my letter to Mr. Lévesque, along with copies of the additional material, was subsequently mailed to each of the premiers of the provinces of Canada. I desire to express my gratitude to Mr. R. Roger Smith, who as my private tutor for almost the entire 14 years during which I served as a member of the House of Commons, brought to my attention facts from the statutes at large, from the archives, and from original historical sources. The material upon which this brochure is based. Walter Kuhl. A long, long time ago, 48 years ago. Still nothing's changed because the system protects itself. People have to understand this. All right, now let's see what Walter Kuhl has to say about the Statute of Westminster. As always, ladies and gentlemen, I will provide a link so you can all download this PDF and read it for yourselves. I will be doing more videos on this material. I've covered it in previous videos, but some of it might be up to 4 years old now, so it's time for a refresher. Here we go. Explanation of the Statute of Westminster by Walter F. Kuhl. The Parliament of a Dominion in Section 2 does not refer to the legislative body sitting in Ottawa on December 10, 1931. The legislative body sitting in Ottawa the day before the Statute of Westminster was passed, according to the Interpretation Act of 1889, Section 18, Paragraph 3, was the central legislature of a united colony whose only function and authority was to aid and advise the Governor General as the agent of the British government. Section 2 does not validate the central legislature of a united colony as the federal parliament of a federal union. A federal union in Canada can be created only by completely independent and autonomous provinces, which Section 7, Paragraph 2 provides for. As a consequence of Section 11, the term Dominion can now be applied to a federal union, and the term Parliament of a federal Dominion can now be applied to a federal parliament, and not be inconsistent insofar as a definition is concerned. However, the British government can no more convert the central legislature of a united colony into a federal parliament of a federal union by changing definitions. Then it can turn water into wine. Just like, ladies and gentlemen, calling the BNA a constitution, Pierre Trudeau changing the name from the British North America Act 1867 to the Constitution Act does not make it a constitution. Exactly the same thing applies here. The only validity which the BNA Act has since December 11, 1931, is a guide to the creation of a federal union which only the provinces can bring about. The provinces of Canada are free to use it as a guide in the creation of a federal constitution or they may reject it completely in favor of a constitution of their own making. As an analogy, it might be said that the relationship between the original provinces entered into under the BNA Act was sort of a shotgun marriage. They were forced into a united colony against their will. The Statute of Westminster gave the provinces their independence so they could consummate a voluntary marriage, but they have not yet done so. Ever since December 11th, 1931, the provinces have been living in common law with Ottawa and have had the right to terminate this arrangement at any time they wish. Now, the detractors out there are going to say, yes, but we all signed on to the Constitution Act 1982, which again I've covered in other videos. So that is our agreement forming a federal union. It was never voted on by the people of Canada. It was never ratified by the people of Canada, and Quebec still has never signed on. So, how can you call that a constitution? Just like back in 1867, Nova Scotia voted against joining Confederation. And the other provinces provided the Quebec resolutions. They got betrayed and they got back the BNA Act, which ensured that Canada was a united colony, a British possession, not a sovereign nation. Anyway, sorry about the rant. Here we are. Here is the actual copy of the actual letter Walter Kuhl sent to René Lévesque. Dear Mr. Lévesque, congratulations on your magnificent personal victory and that of your Parti Québécois in the recent Quebec election. As a student of Canadian constitutional history and of Canadian constitutional problems for some 40 years, I am tremendously interested in the constitutional implications of your recent political victory. Excuse me. For 14 years, from 1935 to 1949, it was my privilege to serve as a member of the House of Commons from the province of Alberta. The withholding of assent to some Alberta legislation in those years by the Lieutenant Governor and the disallowance of other Alberta legislation by the people at Ottawa set me to investigating how these things could be. I was assisted in my studies by R. Rogers Smith, who was personally acquainted with the one-time private secretary to John A. Macdonald at the time when the BNA Act was being enacted. Through this source, I have become acquainted with much information concerning the history of the BNA Act, which is not to be found in textbooks. Gee, I wonder why. All this information has led me to the conclusion that the existing constitutional circumstances are shocking to the point of unbelief. However, in my considered opinion, after 40 years of intensive study, these existing constitutional circumstances are of such a nature that they can be of extreme vantage to you in governing your province. Just like today, even more so today, especially with Alberta. I'm enclosing copies of some of the addresses which I delivered in the House of Commons on the subject, as well as copies of a pamphlet by Mr. Smith dealing with the same subject. If you have not already been made acquainted with this material, I trust it will prove enlightening and helpful to you in the constitutional considerations you obviously are going to become involved in. Although the enclosed material should give you a clear outline of what I conceive to be your present standing constitutionally as a province, I would like to give you a brief summary of what I believe to be your present position. So far as separation is concerned, rather than it being necessary to seek separation rights through referendum, the province of Quebec is already completely constitutionally separated from the rest of Canada. This is equally true for every other province in Canada and has been so since December 11th, 1931 through the Statute of Westminster. How can you be divorced if you have never been married? In other words, ever since the enactment of the Statute of Westminster in 1931 by the British government, each of the provinces of Canada have been a completely sovereign and independent state, and because the provinces have signed nothing since then constituting a federal union and a federal government, and because no such has been ratified by the people of Canada, the provinces still enjoy the status of sovereignty and are privileged to use it in any way they see fit. As you will observe from the enclosed addresses, I quote eminent Canadian constitutional authorities as suggesting that the only and logical solution to the existing constitutional circumstances is the drafting and the adoption of a proper federal constitution in which the provinces can reserve them for themselves any and all powers necessary to enable them to govern their provinces successfully. Once again, this has never happened. The Constitution Act 1982, no one had any authority to enact it. The provinces were all free. The people of the provinces, the people of Canada, did not know the ramifications of the Statute of Westminster, December 11th, 1931. Had they known, do you believe in your heart that they would not want to vote and create a constitution by the people, for the people, elect a government by the people, for the people, rather than live as a British possession, a colony of Great Britain? Just like everyone else in Canada, I believe in the Canada that the idea of Canada that I was taught in school, that I grew up with. When I went to school, we sang "O Canada" every morning. I believe in the rule of law. I don't believe in the color of law that's based on deliberate deception and fraud. And no one's going to save us. No one in this system of control, this illusion of freedom and choice in a system of control, is coming to save you, no matter what they say. Sorry for the ranting. I am sure you can appreciate that if this were done, you could solve your economic and other problems in Quebec without resorting to separation. I feel sure that having the ability to solve your problems and still remain constitutionally part of the country of Canada would be much more satisfactory to your supporters as well to others within your province. The following is a summary of the reasons for the things I have just stated. Number one, at the time of Confederation, excuse me, at the time of the Confederation movement in Canada, the provinces of Canada, Nova Scotia, New Brunswick, desired to form a federal union. The Quebec resolutions of 1864 provided for that federal union. The bill drafted by the Canadian delegates at the London Conference in 1866 also provided for a federal union. The colonial office of the Imperial Parliament was not disposed to grant the provinces of Canada their request for a federal union. The British North America Act, enacted by the Imperial Parliament, carried out neither the spirit nor the terms of the Quebec resolutions. Canada did not become a federal union or a confederation under the British North America Act, but rather a united colony. The privilege of federation, therefore, was still a future privilege for the provinces of Canada. The Parliament of Canada did not become the Government of Canada, much less a federal government. It became merely the central legislature of a united colony. The legislative body, whose only power was that of aiding and advising the Governor General as agent of the Imperial Parliament. The British North America Act was enacted by the Imperial Parliament, was not a constitution, but merely an act of the Imperial Parliament, which united 4 colonies in Canada into one colony, with the supreme authority still remaining in the hands of the British government. Number 9, the privilege of federating became realizable for the provinces of Canada only through the enactment of the Statute of Westminster on December 11th, 1931. Through this statute, the Imperial Parliament relinquished to the people of Canada their sovereign rights, and through them to their provincial governments as their most direct agents. Number 10. Since December 11th, 1931, the provinces of Canada have not acted on their newly acquired status in the forming of a federal union, nor have the people of Canada ratified a constitution. Therefore, the original proposition, namely, that all power to govern in Canada resides at the moment with the provinces of Canada, and all power legally remains there until such a time as the provinces sign an agreement and ratify a constitution whereby they may delegate such powers as they wish to a central government of their own creation. In the meantime, Canada exists as 10 political units without a political superior. And right now, since the enactment of the Constitution Act 1982, we're still acting as 10 political units without a political superior, which is the federal government. The provinces are struggling to do what they want under the boot of this federal government. So, we're acting under a political superior. We do not have a legal and lawful political superior meaning the federal government of Canada in a united federation. Should you consider that there is merit in the information which I have given you, I would be very happy to meet with you in person. Meet with you personally to discuss in greater depth the implications of the unprecedented constitutional circumstances prevailing in Canada. There you have it. Excuse me, from Walter Kuhl. And yeah, all the detractors and lawyers are going to say yes, but legally, the provinces signed on to the Constitution Act. Number 1, it wasn't lawfully enacted. And number 2, not all the provinces signed on to it. And number 3, the people of the provinces, I'm sure from personal experience, were largely unaware what the Statute of Westminster actually did for the provinces, made them sovereign states with the option to use the BNA as a guideline to write their own constitution. You can't just take it. It would be like Canada taking the US Constitution and putting Canada on it and saying, okay, that's ours. That's exactly what happened with the BNA, except for the fact that the BNA was never a constitution. It constituted the central legislature of a united British colony. That's all it did. Um, if you want to learn more, you can watch the previous videos. I will put a link to this document written by Walter Kuhl, and stay tuned for the next video um, about the Governor General. More deliberate deception and fraud. Thank you for everyone that is subscribing and watching and sharing my videos. This is the only way we're going to solve these issues. It's been 94 years since the Statute of Westminster freed the provinces, and we are still living under the illusion of freedom, the illusion of Canada in a system of control. So it's up to you and I and every person in Canada to educate ourselves properly. Thanks for watching. Stay tuned for the next one.